record reflect we are in court in the case of State of Ohio versus Marcus Lashley, 2014 CR 82. The State of Ohio is represented by Assistant Attorney Generals Paul Scarcella and Brian Decker. The defendant is in court. He is in civilian clothing with no restraints. He is represented by attorneys David Grant and Patricia Snyder. This matter is scheduled for an extensive pretrial hearing. We have a lot of things to go over. We're going to be going through the pending motions, the juror list, a few questions that I have for the attorneys, and I know that both sides have been very professional throughout my dealings with you. Because we are scheduled for trial in roughly less than 3 weeks, will there be any difficulty in having all exhibits marked prior to trial so that they can be given to the court reporter and an exhibit list furnished to all parties, starting with you, Mr. Scarcella?
Should not be a problem, Your Honor.
And starting with Mr. Grant, any problem with that?
That shouldn't be a problem.
Are there currently any discovery issues? I'm going to start with you on that, Mr. Grant.
No, Your Honor.
Okay. Mr. Scarcella, any issues?
No, Your Honor.
Any expert witnesses? Have your reports been shared with each other, Mr. Scarcella?
All DNA reports, including updated DNA tests, have all been turned over, Your Honor.
Okay. Anything, Mr. Grant?
Anything relating to the trial phase, yes, Your Honor.
Okay. And I understand the reason why you're bifurcating this. Any photographs or any issues there?
Not at this time, Your Honor. There may be 1 or 2 photographs that may be supplemented at this point, but there would just be photographs that were taken at the scene of the duplicates of other photographs. So I don't think there's any issues.
Mr. Grant?
Not to our knowledge, Your Honor.
Is there going to be any demonstrative evidence?
You know, we'll use photographs. There will be some other physical things that will recover, but I don't believe we're going to have any signs or signs or PowerPoints or anything like that.
Okay, Mr. Grant.
I don't anticipate we'll be using it either.
Do you want to go through your pending motions at this time, or do you want to go into the jurors?
Whatever the court's pleasure, Your Honor.
Why don't we go through the pending motions and then we can go through the jurors? And you do have a package of all the juror responses?
We do.
Defense motion number 21, you filed a motion for reconsideration of an order that other acts be admissible at trial.
Yes, Your Honor. And I assume you'd seen motion 16 was the original motion.
Right.
And then subsequent to that motion, Mr. Lashley was indicted in relation to the Cognac case, which was the case that happened 1 day prior to the present case. And would you like me to go over the facts of the 2 cases?
Well, we had discussed, and I'm going to let you make whatever argument you want to put on the record. I don't have the Cognac case, correct?
Right, correct.
But as a municipal court judge, I issued the search warrant on Brianna Bernard, if I'm pronouncing her name. And that was for her, not for him in that case. And that was disclosed to you. But we're not aware of any conflict for me having issued a search warrant in a different case for a different defendant. So I'm going to stay in this case and we're going to go forward on October 14th. So I have some familiarity with that case because I had personally issued in my prior judicial role a search warrant. So I'm just putting that on the record, but go right ahead and you can make your argument and bring up whatever else you want to say.
Well, the Cognac case occurred on January 26th of 2014. It was a middle of the night home invasion in which 2 men went into the home where there were 4 people present and pistol whipped one of the people, bound her, and rummaged through the house. The following day in the afternoon is when the Nathan case arose. Again, it was 2 people, but this time It was a shooting of a mother, her two sons, mom, and one of the sons subsequently died. After the shooting, when the police arrived, they followed footprints in the snow to a fence by Bonniewood. And on the fence, they found a smatter of blood, which was linked to Mr. Lashley by DNA. They found a fiber, which was linked by DNA to Heather Marks, who was one of the victims in the Conneaut case. And they found a cap, a hat, that was linked to Quan Mathers in the Conneaut case, or in our case. What we learned just within the last maybe 10 days, we got the subsequent DNA analysis, and it turns out one of Heather Marks's hair was on the cap which belonged to Quan Mathers. So, if anything, the evidence at this point is more compelling against Quan Mathers on the Conneaut case. But we also pointed out the problems as far as this being identical kind of situations or so unique as to be permissible. They don't really share anything in common other than both being home invasions. And it just, was our argument that this would be extremely prejudicial, and there is no conviction in the Conneaut case at this point.
Okay, Mr. Scarcella or Mr. Deckman?
Your Honor, thank you. This issue, I note, was raised prior. Judge Mackey was sitting on the bench. He did rule on the case, and that order stands as of right now. In reviewing the latest motion for reconsideration, there is no new case law. There is no new Ohio Supreme Court or United States Supreme Court that would control or change this court's ruling on 404B evidence. And I don't believe the facts are materially different from now and when this motion was originally heard. So we would ask that the law of the case continue, that it stand, that the Judge Mackey's ruling not be disturbed in this matter. The facts as put forth by Ms. Snyder are accurate, and the only further illustration is that the two men in the Conneaut home invasion, they both had firearms, they were both masked, with gloves. They were very similar incidents, and quite frankly, we're going to have to discuss them because we're going to be talking about DNA evidence in the case. The location of Heather Marks' DNA so close to the defendant's DNA, and the matching patterns are something that this jury will have to hear anyway. So, thank you.
Okay, the defendant's motion to reconsider what I'm going to call Judge Mackey's decision on other acts, I'm going to overrule. Motion 22 to permit meaningful voir dire pursuant to Morgan versus Illinois. Go right ahead.
Thank you, Your Honor. Please, court. 292903 of the revised code provides that jurors engage in a weighing process should we get to the sentencing phase in determining what the appropriate sentence would be in this case. In that sense, that particular balancing process they have to engage in requires them to look at aggravating circumstances and mitigating factors. And the code sets up no specific methodology for their doing that. And what it essentially amounts to is each individual juror looking at the mitigating factors, for example, and drawing their own reasoned moral judgment as to what's significant. And in fact, any particular juror could seize upon one single mitigating factor and find that that's equal to any or all of the aggravating circumstances that the state may offer as reasons for imposing the death penalty. And in order for us to gain an understanding of what a person's attitudes are, what their ability is in terms of engaging in this weighing process, it's important for us to engage in meaningful questioning of those individuals. that they won't simply be giving lip service, for example, to the mitigating factors that we might be presenting. Or they're not the type of individual that believes that any time you have an intentional killing, that automatically means the death penalty is appropriate. And there certainly is a significant number of people who feel that way. In addition, I think that a meaningful voir dire, Your Honor, requires that we have the ability to talk to jurors and ask them questions, not only in a vacuum, but as it relates to some of the specific facts in this case, what they're going to be confronted with in this case, and where under those circumstances, they can still fairly consider mitigating circumstances in this particular case, and engaging in that weighing process that the 29-2903 requires. So we're asking for an opportunity to thoroughly question each juror, not only as to the general views of the death penalty, but also relating our questioning to some of the specific mitigating factors that may be involved in this particular case, and some of the aggravating circumstances that they're surely going to hear in this particular case.
Okay. You have the state?
You know, the state understands the need for jurors who understand their role in a capital case. These aren't people who are automatically for the death penalty or automatically against the death penalty, and there are certain nuances to people's opinions with respect to the death penalty if and when it should be imposed. The state doesn't have any objection to a meaningful voir dire. What the state would have issue with is repeated questioning and changing the fact scenario in the hopes of getting an answer that would have someone challenged for cause. You know, I don't anticipate that from defense counsel in this case. I believe that their goal, as well as the state's goal, is to find an appropriate juror who is capable of listening to the facts and evidence and following the instructions of the court. If that is the limit of what we're going through, then the state would have no objection to that.
Obviously, judges are required to take the capital case seminar. This is not the first time anybody's raised this issue in any court in the state. So what the court is going to do is I'm going to overrule the specific meaningful voir dire pursuant to Morgan versus Illinois, but the court will allow voir dire that is permitted by law. We're not going to restrain you, but it's got to be within the confines of the law. So, motion number 23, motion for individual sequestered voir dire.
Your Honor, in that death penalty case is significantly different than any other type of case we deal with in our criminal justice system. We believe, and although it's not a common occurrence, it rarely happens in regular criminal cases, we believe individually sequestered voir dire is important here, because if you get a group of people who are questioned as a group, they tend to be influenced by group answers. People find out what will get them on the jury. If people find out what kind of responses get them off the jury. And many times you don't get honest answers, which is so critical in the context of this type of case. You also get individuals who perhaps are less likely to express their true feelings, feeling some degree of embarrassment of discussing these types of issues in front of other people. We believe that individually sequestered voir dire is the appropriate way to get that accomplished and have meaningful, and it kind of dovetails with the meaningful voir dire motion that we filed in regard to number 22. We believe the only way that the parties can get a true understanding of people's views of the death penalty and whether they can be fair in the context of this case is question of individual.
Okay, on behalf of the state.
While it may be more time consuming, Your Honor, the state has no objection to individually sequestered voir dire. I believe it is, for lack of a better term, cleaner with respect to the record and the jurors' views when deciding challenges for cause.
But at all stages?
For the death, just for the first stage, for the Witherspoon qualification. So as we're bringing them in, would do individually sequestered voir dire once we have them quote unquote death qualified. Then if we have a group of 60, the state has no objection with a general voir dire being with the entire panel. But for the death penalty and for pretrial publicity, those aspects, the state has no objection with individually sequestered voir dire.
I was going to deny in part and grant in part your motion. I would grant it individual voir dire for death penalty qualifications, pretrial publicity, and specific items that are personal in nature to each or any particular prospective juror. But the general qualifications, some of this we're going to do in group because there should not be anything specific. And some of that questioning, especially phase, the first phase of just qualifying them to be on the jury, that I'm going to grant. So Mr. Grant, you want to say something?
Yeah, we were only asking for it as part of the Witherspoon process.
Okay.
But we understand that once we get a panel together who are death qualified, they then be brought in as a group, or however the court wants to do it, be questioned in groups about their general qualifications, such as whether they've been a victim of crime, that kind of thing. But we understand that.
Okay.
Your Honor, if I could make one practical suggestion. If you don't bring up the issue of vacations, work, time restrictions as a group, I found that if you bring that question up to the whole group before the Witherspoon process begins, everybody will come up with an excuse as to why they cannot be here. So time constraints such as planned vacations or work issues, I think should also be brought up on a more individualized basis to prevent the groupthink phenomenon that seems to happen in those
And we can go through that as we start picking them in 3 weeks.
Yes.
I oftentimes don't bring it up at all because if you don't plant the idea, they don't.
But as this case may take a little bit longer, sometimes it's important to bring it up. I just didn't want the court, just a suggestion from the court to not bring it up in front of everybody.
Your defense motion number 24, motion for court to follow 2945.25C standard for death qualification of veneer persons.
Your Honor, we're asking the court to follow the 2945.25C section of the Ohio Revised Code, which is a more stringent standard than has been set forth in federal case law. This is a codification of Witherspoon versus Illinois, where a juror must unequivocally state that under no circumstances will they follow the law in order to be excused for cause. This is versus the Wainwright standard, which basically says that a person could be challenged for cause if their views would prevent or substantially impair them in performance of their duties. It's our belief, Your Honor, that Ohio legislature has expressed a desire that the stricter standard be followed, and it's not in conflict with the Constitution, and it's an affirmation, basically, that the Ohio legislature wants this standard applied as opposed to the less stringent federal standards set forth in Wainwright.
Okay, on behalf of the state.
I think through the individual voir dire process, we will be able to ascertain whether or not a juror is able to follow the law as instructed. Whether that ability to follow the law is for the automatic imposition of the death penalty or for the automatic imposition of some penalty other than death. Those potential jurors who are unable to follow the law with respect to the imposition of the death penalty, we'd ask the same standard be held for them as well.
Okay, we will get you a written decision on that one. If you're going to get written decisions on all these, that will clearly state what is expected and permitted. Motion to exclude veneer persons, defense motion 25, who cannot fairly consider mitigating evidence and who would automatically vote for the death penalty upon a finding of guilt in the culpability phase.
Your Honor, we think this is basically a reiteration of the case law developed in Morgan versus Illinois, that people who would automatically oppose the death penalty anytime there's an intentional taking of another's life, or jurors that would be unable to fairly consider relevant mitigating factors have to be excused. We're simply asking the court to follow the standards set forth in Morgan, and that's what's basically set forth in this motion.
There's a flip side to this coin as well. People who cannot fairly consider the aggravating circumstances or under any circumstances consider the death penalty. Provided that the same standard is applied to both sets of jurors, the state would have no objection.
And that motion, I guess for motion 25, I guess what I will be doing is issuing an order that we will only seat people who can follow the law, not those who have made up their mind one way or another, either for or against imposing the death penalty. Motion, defense motion 27, motion in limine to prohibit victim impact evidence during trial and if necessary the mitigation phase.
Your Honor, it's our position that section 2929.03D1, which is the part of the code which talks about the balancing process and the considerations used in jurors evaluating sentencing in a death penalty case, does not authorize the use of victim impact statement. We acknowledge victim impact testimony. We acknowledge on the federal level there's case law that indicates that it's permissible, but we believe, again, very similar to the argument we made with regard to the Witherspoon versus Witt analogy, that the Ohio legislature has spoken in this area, and the more stringent standard expressed in Ohio is the appropriate standard to be applied in this case. And the introduction of victim impact testimony at either phase of this case would be highly prejudicial to our client.
State.
You know, we have a surviving victim from this matter who will be testifying, one of the individuals who was present in the house that day. We do not intend on asking him how this has impacted him. We will be asking him to testify as to the facts of the case. We do not intend to present any victim impact. If we get to a second phase of the trial, we understand what the law is in the state of Ohio, but it does not preclude us, in our opinion, from having an individual who is a victim himself, as well as a relative of the two people who died, from testifying as to the facts and observations that he had during that day. But again, we understand what the law is in the state of Ohio and intend to follow that.
So you agree that victim impact does not come in during the trial phase?
It would be irrelevant as to the trial phase and would be inadmissible as to the second phase.
Your Honor, in this particular motion, we request that there be a prohibition against referring to the juror's word in this case as only a recommendation. It's our position that informing a jury that the verdict technically is only a recommendation diminishes their sense of responsibility and impermissibly encourages the imposition of a death verdict. Though we believe our jury will tend to approach the matter less cautiously, perhaps. If they think that any mistakes they made may be corrected by someone else at a later date. Caldwell versus Mississippi, the Supreme Court somewhat touched on that type of issue. We believe that as a practical matter, since the death penalty has been in the law of the land or the law of Ohio, there's only a handful of times, if that, or courts ever actually overturn a jury's verdict with regard to the death penalty. It just creates an impermissible inference in their minds that they don't bear what is in fact the ultimate responsibility in making this particular decision.
Yeah, for the state.
Your Honor, the state understands what the law is, especially in reference to the Ohio Supreme Court decisions concerning references to the recommendation. It's never been my practice to refer to it as a recommendation. Neither Mr. Decker or I intend to do so in this case either.
Well, I don't plan on giving incorrect instructions to the jury.
Your Honor, there's two motions that we want to discuss with the court that have not been filed at this point.
Okay.
It's brought to our attention recently that our client was interviewed by an FBI agent on an unrelated matter, and that part of that interview process, at the end of it, there was a conversation between our client and the FBI agent regarding this case, and that potentially certain admissions were made. We would like to reserve the right to file a motion to suppress on that issue should it be necessary. This is something that came up very recently. Mr. Scarcella appropriately told us right away that it happened. We appreciate that, but it did come up recently, and we've had no chance to really react to that.
So you,
If I can, Your Honor,
yeah.
I will let the court and defense counsel know that if the Special Agent McBride, who's the agent in question is called to testify, he will not be asked about that interview.
The other motion we wanted to file, Your Honor, was a motion in limine prohibiting the state from eliciting testimony about our client's alleged gang involvement.
I thought we were bringing him in a couple days ahead of time.
We're gonna bring him in 100 on, I believe it's Wednesday, 125 on Thursday, 125 on Friday.
That's right.
That's a summons. We're gonna bring them in, do the initial qualifications for jurors, give them that questionnaire, have them answer it while they're still physically on this, I'm gonna call it campus, because we're in two different buildings. And then we would, the plan was to make attorneys for both sides copies of those so that you would have that information available to you. And then when we go back to the jury selection process on Monday, you would have that information. You would have had Saturday and Sunday to study that information.
I just want to make sure that I had it right in my head. I just wanted to make sure we were square.
Wasn't that what, I thought that's how we agreed to meet?
That was, but I just wanted to make sure that that's what I remembered. I apologize for asking.
And I tell people there's more to being a judge than just trying a case. You gotta manage the case too, and that's part of the management of the case.
Thank you, Your Honor.
You're obviously here today. They treating you okay in jail? Things are going okay?
Yes, Your Honor.
You're getting a chance to talk to your lawyers?
Yes.
Okay, I believe at least one or both of your lawyers actually arrived quite early today and met with you, right?
That's true, Your Honor.
So you've had a chance to talk to him about everything you need to talk about?
Yeah, for the most part, yeah.
Okay, has he answered all your questions?
Yes.
And you're satisfied that they're working hard and doing a great job for you?
I am, Your Honor.
Okay. Is there anything you wanted to bring to my attention, but before you say anything, consult with your lawyers, because I don't want you blurting anything out that they don't want you to say. Now, throughout the proceedings, the jail warden has been here. I believe he's attended at least several of these, so that if there's been any problems or complaints, we could bring that to the Lieutenant Kimberly's attention, but you've indicated that you're being treated properly in the jail, so we're good there.
Yes.
Anything else, or we're gonna break for today, because you still wanna file a motion, I'd range late to file that.
Nothing to say.
Okay, anything on behalf of the state?
No, Your Honor.
And then should I schedule any hearings in between now and the 14th?
Not at this point. If something comes up, obviously we can contact the court.
Okay, I'm here all day, every day. If you guys, when I say you guys, I'm talking about the four attorneys, Ms. Snyder. If for any reason there is something that the attorneys wanted to bring to the court's attention, obviously Mr. Lashley's in the building, I'm in the building, just give us a few minutes notice that you're coming and you need to talk to me. As I've done in the companion case, I will work you in and get you in. Okay, fair enough? Because this is a priority case, and we've tried to extend Mr. Lashley all the professionalism and fairness that we can possibly grant any defendant. So if there's nothing further, we will be adjourned.
Your Honor, did you want the questionnaires back? Or were these our copies to keep?